Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot-off-the-press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti. Today we are delighted to present a great panel called Whatever Happened to Global Cartel Enforcement. The panel is sponsored by the Cartel and Criminal Practice Committee, and with me to provide some context is Lindsay Valla. Lindsay is counsel at Vincent & Elkins and also is the co-chair of the Cartel and Criminal Practice Committee. Hi, Lindsay.
Hey, John. How are you?
Good. So, Lindsay, what are we doing today?
So we are going to talk about the current state of global cartel enforcement. I'm excited about this panel. It's a fantastic lineup. Cartel gurus from three of the most active continents in terms of enforcement in this space. We've got North America represented, Asia, and Europe. And they're going to enlighten us not only about what's happening globally, about enforcement coordination, but also what's happening in their respective corners of the world.
Great. And why is this important?
This has been an ongoing discussion in the cartel bar and frankly, the broader antitrust bar across the globe. It was a major topic at the recent International Cartel Workshop that the section sponsored in San Francisco in February. There were a number of panels at that workshop that tackled the question of whether leniency applications are down, whether global enforcement and coordination are down, and if so, why. And so I think these voices today are going to deepen the discussion about this important issue.
Great. Let's send it over to the moderator, Brent Justus. Take it away, Brent.
Thanks, John. Until recently, global cartel investigations dominated the headlines. It has seemed clear that coordinated international enforcement would be the way of the future. But with the recent decline in blockbuster investigations, many question whether this trend has played itself out, and if so, what lies in store. My name is Brent Justus. I'm a partner in the Antitrust Department at McGuireWoods, and I'm the co-chair of the Antitrust Section's Cartel and Criminal Practice Committee. I'd like to welcome our panelists who are joining me from 3 different continents and 4 different time zones on this adventure to convert our spring meeting panel into a podcast, which might be the first podcast for some of us, so hopefully people can bear with us. First, I'd like to introduce Lisa PHELAN. Lisa was a cartel prosecutor for 30 years at the DOJ's Antitrust Division. In her last 16 years there, she served as chief of the National Criminal Enforcement and Washington Criminal 1 sections. Lisa was lead prosecutor on one of the earliest international cartel investigations involving the fax paper industry and supervised many of the major international cartel matters of the past 2 decades, including the air cargo, freight forwarders, ocean shipping, and auto parts cases. Lisa is now a global antitrust litigation partner at Morrison Foerster and represents global companies and their executives as they navigate multi-jurisdictional cartel investigations. Next, we have Atsushi YAMADA. Atsushi is a partner at Anderson, Mori, and Tomotsune, focusing on competition antitrust law. His practice covers all aspects of competition antitrust law, including assisting clients in investigations by competition authorities, representation in courts, tribunals, challenging decisions made by competition authorities, and follow-on litigation. Prior to joining the firm, he has served as a judge at the Tokyo District Court, as well as other courts, and with such background, he also has extensive experience in litigation. I'd also like to introduce Marisa TIERNO CENTELLA. Marisa leads cartel investigations in the financial sector at DG Comp, including, amongst other things, investigating a record 35-year-long cartel in the feed phosphates case, which was the first application of the EU settlement procedure, and the worldwide gas-insulated switchgear cartel. Marisa drafted the legislative packages introducing EU settlements in 2008 and the 2006 EU leniency notice. Before, she was an official at the Dutch Competition Authority for 7 years and practiced law for 5 years at Gomez, Acebo, and Pombo. And I also understand that Marisa has worked and published in Spanish, English, French, and Dutch. So she's going to have to dumb things down for us a little bit here on the phone today. Finally, last but certainly not least, we have Heather NYONG'O. Heather is a litigator, first-chair trial lawyer, and trusted advisor to multinational corporations and executives facing complex investigations and litigation. She brings her experience and insight to government investigations, including those that result in criminal or civil litigation. She has more than 18 years in the antitrust space, including serving in the Antitrust Division of the U.S. Department of Justice. Heather is currently a partner at WilmerHale. All right. With their introductions behind us, and just trying to deal with our technology here for the first time, let's talk about the premise of the panel to begin with. Is it even fair to say that we've seen a decline in global cartel enforcement? Lisa, let's start with you. From your perspective of 30 years as a leading cartel enforcer at DOJ until relatively recently, do you see the decline in global cartel investigations as a trend or a moment in time?
Well, I think that's a really good question, Brent. Thanks. I think it's a little bit of both. I think there are some trends here. I mean, after being an enforcer for so many years, I'd like to think that after sort of a global consensus that developed over the last 25 years, that these are serious crimes and that there needs to be significant penalties. I'd like to think that there's been at least a little bit of both education and deterrence that has come from many global companies. I think more companies are, when I first started out with the fax paper case back in the 1990s, I think it was really a shock to some companies that hadn't previously operated on a global scale and were used to using the business norms that were common in their country. And when they moved into the global sector, they didn't fully appreciate how different cartel enforcement was around the world. And so there was a lot of misunderstanding, and it took a while for companies to fully get what is expected and how you need to operate in a global environment. So I think that was part of the dawn of so many cartels being uncovered early in the early years that we were doing it at DOJ. But I think at this point, the process is more mature, and that a lot of companies get it, and they have stronger compliance and enforcement within the companies. And so there is, I think, therefore, a bit of a downturn. I think another factor, of course, is that after 25 years of seeing the whole process of global enforcement play out, it maybe isn't as much of a no-brainer as it was in the early years for companies that might uncover some conduct internally, whether or not they want to immediately approach the agencies, because they can now see that they're talking about taking on at least a decade, if not more, of not only dealing with government agencies around the world, a dozen or more potentially, but also, as I know we'll talk about later in this session, the civil cases that are inevitable. And so I think those factors are leading to a bit of a downturn in applications of type A leniency. But I also think this is a bit of a moment in time, in the sense that perhaps I'm cynical, but I think there's just too much of a temptation for competitors to get together and coordinate what they're doing. And that could be not only in a robust economy where there might be a temptation to get together to talk about being even more profitable or driving prices higher, but in particular, and I worry about that right now, when there's not such a robust economy, or there's a crisis or a problem or a declining market, there can be a real pressure that companies and executives feel to sort of stop the bleeding and perhaps put a floor on prices, or deal with their competitors to see if they can't kind of divide up whatever pie is remaining. So I think in some ways it's a moment in time, and that there will be an uptick again in global cartel investigations and prosecutions.
How does this relate, Lisa, to the overall trend in division cases we've seen over the last couple of years?
Well, it seems, and it's hard to know what's chicken and egg, right, in terms of whether DOJ is choosing to focus on some more domestic cases or whether it's because there's a lack of detection of global cartel cases. But there's no question in the last several years, DOJ has and they've publicly stated it, focused on some areas that tend to be more domestic oriented. One of those is the no poach cases. That has been a real priority with the division. And those, at least the ones we've seen under investigation to date, seem to be more domestic agreements relating to the labor market. And then also government contracting. They announced some months ago that they were starting a major task force to focus on companies that sell products or services to the government. And I would imagine, again, with this crisis that's ongoing now, where the government is contracting in a huge way and pushing out tremendous amounts of money and contracts, that'll be a continued focus. So there's only sort of so many attorney resources at the division to go around. So the more that go to domestic-oriented cartels, by definition, there's just fewer to go towards global, the hard work of detecting and then investigating global cartels.
Okay. Let's go to Atsushi for a moment. Are you seeing these same sorts of trends in Japan?
Thank you, Brad. Yes, sort of. I think it depends on which point in time you compare with. If you compare with maybe 7-8 years ago when we were seeing so many cases from the auto parts cartel, yes, the answer would be yes, we see decline. And if you look back the last 1 or 2 years, the JFTC formal orders, there is no international cartel cases coming out there. However, if you take a broader look at the more dynamic move, you'll notice that this is more likely to be something, a moment in time. One thing that I would like to mention is that ever since the JFTC had introduced leniency back in 2005, leniency has become the main driver for enforcement by the JFTC. And the JFTC actually publishes the number of applications made for leniency. And if you look at that statistics, you will notice that there's not a huge decline in the number of applications made by the companies. So while if you look at the this last year or two, you might not see much international cartel cases coming out of the JFTC in the form of formal orders, but there are cases in the pipeline in the leniency applications, and the JFTC is surely doing their job. So I think it would be more like a trend that we are seeing for this moment in time.
Okay, Marisa, what about the European perspective? Are you seeing a decline in globally coordinated cartel investigations, and if do the statistics reflect that?
Okay, so I understand that you are looking at this because other competition authorities that are indirectly represented in this talk have the choice to go after domestic, national cases and international cases. The European Commission doesn't have that choice because we deal with cases that are supranational, international always, since they need to affect trade between member states. Now, if you think that those international cases are domestic, just taking the perspective of the European Commission, even if it is different member states, and then we distinguish that from the global cartels, depending on the year, between 45% and 78% of those international cases we have are global cartels. So if you look at the average of the last 5 years, they always represent more than half of our cases on average. And then what I have to say is that whenever we deal with a global cartel, we have contacts with the other authorities in order to have some form of coordination as a matter of course. So that is established practice that is sustained over time. Obviously, now the number of enforcers has proliferated enormously. So we cannot just coordinate with one or two. We often have to deal with more. I mean, in some of my cases, I have been talking to 7 agencies, for instance, financial cases. Now, what I have to say is that the depth of the coordination, of course, is different depending on the cases and different depending on the authorities at the other side. So there are factors such as the investigation timing, whether we are all at the same moment of the investigation or similar moments, or somebody has come in much later. Typically, for instance, when we start with leniency, it's often the case that leniency applicants go to the US, come to us, sometimes to some other agencies, and then they have a second round of agencies later on. And then we are at different moments of the investigation. It also depends on the respective progress and also the perspective, whether the other agencies feel that they can pursue the case or not, and the same for us. And then it also depends on the legal framework for the exchanges, whether we have waivers, whether we have bilateral agreements, and which are those, And of course, it all depends on trust. So it depends also on the established record of cooperation with the authorities in reciprocity. And the limit is that we cannot undermine in those exchanges the warranties that we provide companies in our legal framework. So just to give you a taste, and I will end with that if you don't have questions, is that with Switzerland, who is in Europe but is not a member of the EU, we have a second generation agreement, which is the closest we can have with a non-member state, which enables us to exchange even evidence gathered with our respective powers of investigation. So I could conduct an inspection, for instance, within the EU, and they could conduct an inspection within Switzerland, and we could theoretically give each other the evidence. But then for leniency, we can only do that on the basis of waivers. So that is the closest cooperation we have. And we are working on similar agreements with Japan and with Canada at the time. So for us, cooperation is a must in all global cartels, and we don't see a decrease in our practice.
Well, and I wonder, Marisa, whether, how much of this perception of a decline, is attributable to sort of, rather than an actual decline, perhaps more of a perceived decline in the coordination among enforcers around the globe. Heather, going to you for a second, drawing from your experiences on the defense side in cartel investigations, are there any changes you've observed regarding sort of the coordination among global enforcers in criminal cartel investigations?
I think it goes back to something that both Lisa and Atsushi said, which is the sort of chicken or the egg kind of concept. As Atsushi mentioned, we really haven't seen cartel enforcement at the level of massive coordination among many jurisdictions really since the auto parts investigation. And so it might seem that coordination is down, but it might be more that leniency applications of the nature of it hitting various jurisdictions are down, not taking into account Marisa's very good point, which is that in the European states, member states, of course, those are international cartel cases that the EC deals with, but I'm thinking of those that involve parts of Asia and also the United States. Those cases certainly are not at the level that we saw back in the LCD or DRAM or capacitors days, which is, now dating back at least 6 years. The financial services cases are different. Those have been in between, of course, those Asian cartel investigations and today. And I will say that from my experience of observing those, I think the coordination has certainly improved. Used to be the situation where folks would complain, and I imagine there still are complaints when there are large investigations hitting various jurisdictions, but folks would complain about the fact that some jurisdictions do not have paperless process. They get ahead of the European Commission and United States in terms of interviewing witnesses from a leniency applicant, creating a difficult record. And I do feel that as the international community has really started honing in their programs, that they have been more mindful of the concerns in these various jurisdictions, particularly related to the civil process and the discovery that the civil litigants can have to face that involves records they're creating in other jurisdictions. I think that has been substantially improved, and I suspect that folks are a little bit happier with the coordination among the jurisdictions with respect to how they've at least are learning from each other and taking into account what's happening in other jurisdictions. There also was a lot of complaints back in the auto parts days in particular about double counting in the various jurisdictions. And there was a real demand within various countries to ask their agencies to focus more domestically. I suppose it was probably not the defense community who encouraged agencies to look more domestically, but I do believe, and I think that the folks in this call have underscored this, that there has been much more of a domestic focus. And if we look at, as Marisa said, the domestic focus being within the continent of Europe, it seems that there has also been that with respect to the EC as well. So, and I don't know if that's because going back to what Lisa said, which is that overall there's been deterrence at a global level. I do think that she's right that we're going to see something that's coming out of the current pandemic and crisis that we're facing now, probably across the globe. And also we'll see it more domestically. Of course, DOJ and FTC have given guidance that for certain essential industries, they might be relaxing collaboration standards and things of that sort. I suspect that around the globe and even here in the US, folks are going to cross that line pretty quickly, given the really desperate times that we're in. So I think that the Antitrust Division and all of the different competition authorities across the world are going to start seeing leniency applicants probably, in the coming months after we've are entered into the recovery phase.
Marisa, you spoke about you saw the sort of value international cooperation. You're not seeing really a decline in that. Could you talk a little bit about complementarities between the different enforcement regimes when dealing with global cartels? I know Heather sort of addressed what used to be concerns about sort of double counting and the lack of paperless processes. Looking today, do you feel like the global enforcement authorities do a good job of complementing each other, or not?
Well, here is the moment where I remember that I am the only one who is currently in an agency, and I should start with a disclaimer that my opinions do not necessarily reflect those of the European Commission. So blame me for them. Look, we have invested a lot in international cooperation at the level of the ICN and of the OECD. I have sometimes used side meetings in those opportunities to discuss cases actually with colleagues who were also doing those cases in their jurisdiction. So we have had sometimes gatherings that were bilateral and sometimes gatherings with 5 and 6 enforcers taking advantage of that. So we really care about the possible discrepancies and the conflicting requests that we would be making, impossible timing for parties. We do care. Sometimes it is not possible to align on some of the issues, but we take it seriously. Maybe I'm a bit biased because all my investigations are global. Now, concretely on the point where I made a disclaimer because it's only my opinion, I would personally argue that global cartel enforcement can benefit from complementarities of the two main enforcement models or paradigms, if you want to call it like that, around which the other enforcers gravitate. I'm not speaking now saying European Commission, DOJ. I'm saying systems that are similar to those. There is the prosecution model, and there is the other model of the authority that can take the final decision and then be challenged in court. And if I just take the European angle to give a couple of examples or points. First, if you look at the EU cartel concept, which is driven by the purpose of the conduct, it allows us to address a wider range of intentional and negligent anti-competitive collusions than what some jurisdictions can tackle as cartels. So our contribution globally makes that some seriously harmful practices can be discouraged, whatever their form, by addressing practices that other alternative enforcement models cannot address at all, or that would be able to address it only if they could prove anti-competitive effects, not by object. So we have the possibility to capture as cartel conduct concerted practices that fall short of outright agreements, for instance. And I'm thinking now, for instance, of exchanges of information, forward-looking commercially sensitive information between competitors. When this is meant to coordinate market behavior or to influence the relevant parameters of competition, we can get them down as cartels. And then what we consider relevant parameters of competition that can be influenced or coordinated go beyond the traditional ones like prices or volumes. They may encompass things like access to information or expert risk management, for instance. So this flexibility has enabled us to capture buying cartels, cartels restricting innovation, manipulation of benchmark rates, cartel facilitators, and in the future we may be confronted with other things. And then the second point is that the European Commission resorts to very significant fines to ensure enforcement in a jurisdiction where administrative sanctions are widely perceived to be commensurate to the violation, because if that perception doesn't exist, then enforcement doesn't happen. These fines can go up to 10% of the total worldwide turnover of the corporation. Actually, in the last 4 years, we have imposed 8.2 billion euro on companies in international cartels. However, compared to other systems like we are speaking at the ABA, so like the American system, the US, we do not address individuals and we cannot put them in jail. So there are other authorities who make that contribution to global enforcement. I would personally argue that if we were dealing with the same cartel infringement, there would be little complementarity in obtaining, again, a jail sentence for this.
Lisa, could you talk a little bit about sort of your experience of the state of coordination among enforcers when you left DOJ in 2018, and your perspective, has that
I can say
changed over the last few years?
Amazing how it changed from the very early years, 25 years ago when we were doing ADM and fact paper. There was very great reluctance on the part of other enforcers to want to coordinate, to share information, and to do assistance requests for the U.S. There was a perception that because of their criminal laws and because people were put in jail, that perhaps the U.S. was overly aggressive. And I won't quote the jurisdiction, but one jurisdiction in a case where we asked for if they would do search warrants for us or interview witnesses, took about a year and a half to consider it, then kind of reluctantly said yes. And then when we traveled there, basically confronted us and said, isn't this all about embarrassing us in trade talks? And of course, I had no idea what trade talks were even going on, if they were. And so from those early years where it was a real challenge, it was amazing to see over a relatively short period of years the total sea change in the attitude of enforcers around the world and the cohesiveness and the consensus that grew. And it was really a pleasure to be a part of, to everyone sort of coming to see how serious these offenses were and how important it was to respond to them together, and the impact that it could have when multiple jurisdictions around the world were working closely together. So over time, many of them, and it's publicly known, many of the major investigations like air cargo and freight forwarders and the electronic components cases were investigated. Search warrants were done, gun raids were done globally around the world, almost simultaneously in a very coordinated way, and that was just amazing to see. And I don't think that's changed, except I think in the last few years there's actually been some lessons learned and some reasons why perhaps we're a little bit over realist in looking to share and do everything kind of together, because I think in a couple of recent court rulings and also in just finding out about discovery, once some of these cases go to trial, that there could be some problems potentially if each jurisdiction has sort of different rules under which they interview witnesses. I'm thinking of the LIBOR case where there was a problem where witnesses were interviewed under the UK set of rules, which would be different than in the United States. And then the fact that that happened created a problem when there was a trial in the U.S. And I know myself, and even in some of the early cases in terms of discovery, if you're doing parallel investigations, other jurisdictions might have very different rules or obligations or practices in terms of releasing material that, say, the U.S. would have preferred not be out in the public before grand jury indictments happened or before trials happened. So I don't think there's been any downturn other than, as Heather noted, because there's just been a downturn in the number of international cartel matters ongoing right now. I think there's been a little bit of pulling back and realizing that you need to fully understand the other jurisdictions' legal practice and the implications of that for prosecutions in the United States. And you need to have some caution in feeling totally comfortable having completely shared information. Another really interesting development in coordination with other jurisdictions is the several recent examples just this year of jurisdictions being willing to extradite antitrust defendants. As you know, it took a very long time before the first person was extradited for a Sherman Act offense, and that was Romano Prisciatti about 5 or 6 years ago. But just this year, two fugitives from justice in major international cartel investigations were extradited to the U.S. One of them was Meta Oolings, an airline executive from the air cargo investigation, who was indicted more than 5 years ago, but I guess didn't realize it and traveled and was extradited to the U.S. And also very recently, a Korean executive of an auto parts company was also extradited. So that is a huge leap in coordination and cooperation between jurisdictions, which is something that took a long time to come, but now it seems to be a much easier call for jurisdictions to do.
Well, one thing we can't but help talk about when we address this issue of the perceived decline in global coordinated cartel investigations is sort of something that's a hot topic right now in the U.S. with that CAPERA coming up for reauthorization. But many people in the cartel world you'll talk to, point to sort of the boogeyman of private litigation and the lack of any real protections presented by CAPERA, and point to that as the real reason that it's not because of a decline in global coordination, but rather it's because of the consequences of private antitrust litigation are so high that that's really attributable to the decline in these global blockbuster going everywhere cartel investigations. Heather, as an antitrust defense lawyer in the private litigation capital of the world, what is your perspective on how much of this decline in global cartel enforcement can be ultimately traced back to the ever-growing exposure to private antitrust litigation for amnesty applicants?
Well, Brent, I will definitely say that private litigation is not a boogeyman. He is alive and very I'm not sure if someone is faced with a clear cut on its face cartel problem that they won't take advantage of leniency. It is just too attractive of a carrot. And there is always a fear, the prisoner's dilemma, that others would come in and see how attractive that is as well. I don't think necessarily CAPERA is what's so attractive about leniency these days. I think it really is the fact that, you've got executives in the United States who will not be criminally prosecuted, including formers if you do enough in terms of their cooperation to perfect the leniency, such that it makes leniency extremely attractive. But I will say the decision to come in for leniency, I think, does take much longer. And the decision to report, even though the division is quite good about considering applications where it may not be as clear cut and actually dropping them when it doesn't rise to the level of that the government would feel comfortable going in under a per se criminal standard, of letting the parties just walk away as if nothing ever happened. those things still are very true and real and therefore attractive. But the fact of reporting something, you never know what could happen in terms of a potential plaintiff private litigation case coming forward, especially if the division sees enough there that they decide to open a grand jury and then maybe go away and decide that there is not enough there to get to the point of plea agreements. But then, of course, you have litigation, and it can be devastating to a company to be involved in crippling civil litigation, not only because of the joint and several liability and the risk of treble damages and what companies will pay in terms of fines that really outsize in many situations any potential harm, but also the length of this litigation. I think the DRAM case, the civil litigation, was on Judge Hamilton's docket, I think, for about 14 years. You've heard of it being even longer, and Marisa can speak to this in the EC. Now with private litigation becoming even more prevalent, and the cases sometimes in the EC and how long they last, we could just see folks having real cost-benefit analysis that they undergo that when they're making the decision. It might even factor into a company's decision to even plead guilty because of the prima facie evidence you have there, and companies taking longer to reach plea agreements with the antitrust division as a result of what that does to their liability in the civil cases and the ability for plaintiffs to use that in a very serious way against litigants in those cases. I think, if there was a way that I could recommend, plaintiffs are not going to go away. There's no potential for that. But there is some discussion in the community about whether ACPERA should be strengthened, and in fact, whether the leniency applicant should receive no damages for coming in and cooperating fully with the plaintiffs when the DOJ permits them to, such that the plaintiffs can build even stronger cases against those who are not cooperating with them. And in exchange for that, like with DOJ, get a free pass. That, I think, would not only strengthen the resolve of companies to come in and seek leniency with the government, but also would help substantially with the plaintiffs in pursuing their cases, because right now there's a substantial tension that they face where they have an ACPERA applicant, but who also is working very hard to limit the scope of the damages in the civil cases, and it really does make that process go, I think, a lot. It's a much more difficult process for plaintiffs in terms of extracting settlements early on.
Yeah, I think that's a whole different panel. The ACPERA tension. I know we, in the Cartel and Criminal Practice Committee, we tried to submit some comments on behalf of the section on the sort of expiration of ACPERA and what the problems were with ACPERA, and we were unable to reach a consensus that there were even problems with ACPERA. So, it's certainly a live topic, and maybe for next year we could deal more fully with that. I'd like to take your invitation, though, to toss this to Marisa and ask her if she could share a little bit about how the EC goes about trying to strike this balance between, the encouragement of leniency applicants and, their exposure as a result of, coming into private litigation.
Yes, it is very interesting to listen to what has just been said, and to also follow the discussion regarding ACPERA, because of course what happens in one jurisdiction affects indirectly what happens in the other jurisdiction. Obtaining leniency from the European Commission does not require companies to have satisfied damages to their victims as a previous step. For the American audience, I want to explain that leniency in the EU covers not only immunity for fines or from fines for the first in, but also decrease in fines reductions for subsequent companies who contribute with significant probative added value to the investigation. So when I say leniency, I cover both. When I say immunity, is more equivalent to the amnesty applicant. Okay. So we don't require companies to satisfy damages to obtain leniency, but any commission decision constitutes irrefutable direct proof in court before any judge in the European Union of the existence of the infringement and of the participation therein of the relevant undertakings, and that includes the immunity applicant. However, all this is subject to the precise terms of the decision. So any further allegation by a damage claimant that would exceed what you have in the decision has to be proven independently in the court proceedings. And there are no particular obligations of the immunity applicant to help those litigants. Okay. So then on top of that, the main differences in EU damages actions compared to the US, and this was introduced through directives in the last years, is that one, EU damages are meant to provide full compensation for the losses and for the missed gains, but they are not punitive. So we don't have treble damages, for instance. The principle that the loser pays the costs. So in order to prepare a damage action, you have to take the risk that you will lose. Then in principle, in Europe, victims have to opt in to class actions with some exceptions. While in the US, normally I understand that the victims have to opt out. And then we do have the possibility of the passing on defense, and indirect customers have standing to claim damages under some circumstances. So in that framework, that as you see is already very different in the balances from the US, EU successful immunity applicants do not get a fine, but as I say, they get a decision establishing their participation in the cartel, which means that next time around they will be recidivists and they can receive a 100% increase on the fine for that, and they are subject to damages claims. But on the other hand, all leniency applications are protected from discovery, and successful immunity applicants are only liable for the damages they have produced to their own customers, while all other cartelists that appear in the decision are jointly and severally liable for the rest of the damages produced by the cartel. So that's how that is the balance we have chosen in the EU. So I would argue that there is a very clear scoping because of the decisions of the Commission when it all starts there. And then there is a good level, I think, of legal certainty for damages claimants who are helped, but they are not helped, to the extent that they could abuse the system.
What I'd originally planned on us transitioning now to talk about what global enforcers are doing to, combat the decline of global coordinated cartel investigations. But I guess we really haven't, just as an initial matter, reached a consensus that there is really any decline to try to combat. But I think we can still talk about, what enforcers are doing to sort of, keep the momentum going, right? If we don't want to, reach the conclusion that there is a decline, I think we need to talk about, what steps enforcers are taking to make sure there isn't a decline. And I'd like to start with Atsushi, because I understand that Japan recently has amended its competition law in a fairly significant way, which increases the incentive for companies to cooperate. Could you let us know, explain those changes, Atsushi, and opine on what motivated those changes?
Sure. Actually, this amendment was enacted last year in 2019. However, I would like to note that the law itself has not yet come into effect. It's supposed to come into effect sometime this year, but the specific date is not yet decided. As for the substance of the amendments, I would say there are two main features. One would be revision to the leniency system. And I would like to note that in Japan, the leniency system would include immunity and leniency, both would be included. And the second factor would be strengthening of enforcement. Going to the first item, revision of leniency, formally, or maybe I should say currently, the way the leniency system in Japan works is that once you apply for leniency and that is approved, then you would be secured a fixed reduction rate. For example, well, for the first in, it would be immunity, but for second in, you would get a 50% discount, and for the third in, you would get a 30% discount. So the reduction rate would simply be determined by the order of the application. However, with this new amendment, this fixed rate does remain, but the weight placed on this fixed rate will be reduced. And what would be newly introduced is a flexible rate that would reflect the degree of cooperation. So, for example, for a second in applicant, there would be a base rate that would be determined based on the order of the application, but this would be 20%, and the flexible rate would be anywhere between 0 to 40%. So that allows the agency to have a little bit more discretion. And the whole idea is that that should urge the companies to cooperate more to the system. And with this additional reduction, that might encourage more applications. The other prong of the amendment, strengthening of enforcement, I think there are some features that I would like to introduce. One is the period of calculation that would be used for determining the base rate of a fine has been extended from 3 years to 10 years. So companies would be facing a larger fine depending on the length of the collaboration. And also, the statute of limitation has been extended from 5 years to 7 years. So the risk for the company that is under investigation has increased. So in this two ways, the Japanese authority has tried to increase incentives for the companies to cooperate. Going to my personal opinion regarding these changes, while it is true that this would provide more incentives for companies to cooperate, I should like to note that there's another idea behind this amendment. Ever since the leniency program was introduced in Japan, it has been quite successful. So my take is that the JFTC has been quite comfortable with its success. So the other idea that they had with this new amendment is that they wanted to have a more effective enforcement system. So that is another idea that is feeding into this amendment. I will stop here.
Marisa, what's DG Comp doing to sort of keep make sure that there are cartel cases in the pipeline, assuming that we don't have a decline and we just want to keep the momentum going? What's EC doing to keep the momentum going?
Yes, well, I think that one thing is to say that there is a decline in global cartels, which, as I say, not in my practice, but I don't know whether worldwide there is a decrease. The other thing is that we have seen that the figures for the first in leniency globally were not at the top in the last years. So we think that it is very important in order to have cooperation from companies that it is clear that agencies can go after cartels also ex officio. And therefore, already in the previous mandate, the European Commission had made a substantial investment in digital investigation methodologies and intelligence gathering. And those initiatives are now delivering. So our commissioner, now vice president of the commission, already announced in the last ABA the setting up of a dedicated unit that is staffed with computer experts and forensic intelligence capacity, who sits in my corridor at the commission, and who have been working on improving data analysis. We have also established a centralized network of intelligence that comprises all our national enforcers and also the other Commission Directorates General and agencies who provide leads and flag potential competition issues to DG Competition. And then we introduced in 2017 the whistleblower tool, which established a channel, an application to have insider information, reaching the commission services and interacting with us in full anonymity. The difficulty is that it was not difficult to get, somebody giving you a lead, but then it was very difficult to go back to that person, to that individual, if it was simply a message. And with this tool, we are able to interact while preserving their anonymity. All that is delivering, and now over 25% of our currently open cartel investigations have started ex officio. That represents, we think, a healthy proportion to maintain, the perceived risk of detection and the incentives to self-report. Then the other point is that once a case is uncovered, be it ex officio or by immunity, the features of our leniency program usually trigger leniency cooperation in all cases, or in almost all cases, because then undertakings try to race for the decrease in bands of reductions of fines. And that means that they have to provide insiders' evidence representing significant probative added value compared to what we already have on file, to help the Commission to discharge the burden of proof. So what we have done is that we have maintained the features that make our leniency program predictable and attractive. And we have added in the last year the e-leniency tool. This e-leniency tool is to be blessed in the current situation because we are all teleworking. This enables companies and lawyers to submit applications, documents, the corporate statements, also settlement submissions, 24 hours per day, 7 days per week, by typing them directly online into the e-leniency tool without leaving any trace for discovery purposes. So there is no trace left in their own devices. And e-leniency has been immediately adopted by the legal community. We receive a high number of submissions through this channel, which is really user-friendly. And as I say, it is saving applications at this time where we are not at our premises and the lawyers are also not at their premises. So this is what we have done to maintain the incentives and to make sure that we have ex officio cases. Of course, as I have said in a previous conversation with the panelists when we were preparing this, what you see in the records of any agency now is the work of the previous years. What is now in the pipeline will only be seen in some years from now. So I'm giving you an insight in what is happening now that it is not yet obvious in the records.
Marisa, we didn't talk about this before, but I would be remiss if I didn't ask you to just give us a little bit of more of a description of what digital investigations and forensic analysis means. I mean, I'm not asking you to disclose any secret sauce or anything like that, but for us who are intrigued by that sort of thing, is there anything you can share about sort of methods or strategies that wouldn't get you fired?
Yes, I will try to think. I will talk to my lawyer. So let's say, as you know, currently we have two issues. First, that there are some business models that are basically online or that depend a lot on data, and even when we go on inspection these days and we come back with enormous amount of data that normally it would be very difficult to be processed just by human people, a few people. It would take years to process all that information. Although we target the information, we don't come back with everything that was in the company. I mean, we have ways of doing this, but we have tried to get these specialists to empower our investigations so that we can turn to data mining. So it's knowledge discovery in data sets, machine learning. So there are computer systems methods of learning by way of examples, so that we can draw conclusions. Of course, that afterwards have to be seen by human personnel. It cannot be just the machine, but it helps you in seeing patterns, for instance, in seeing connections. And then there is also deep learning. And these methods, I understand they are implemented by means of what they call the specialist neural networks that are organized in different layers. I'm really not a specialist on this, but I know that they use machine learning algorithms in data mining analysis. I know that because I get sometimes reports from them where they have applied these principles. And then they exploit the big databases and they try to predict the relevance of information contained in specific databases for the investigation. And often what they do is that they present in graphics, in the form of graphics that are visual, that help you to understand things in a different way, the information that they are able to obtain. So let's say that they create new knowledge from the data sets that we have, and then they are able to present the results in a way that users who are not specialists can rapidly and efficiently locate the potentially interesting information, to sometimes disregard some parts of the information you have and to focus on some pieces of information. And they also, they see complex patterns within the data. So that's a bit what they do. I don't know whether I have explained it in a way that is understandable, but I'm not a specialist. I have just benefited sometimes from what they collect and what they are able to give us.
Well, if we could understand it completely, we probably wouldn't be lawyers, I think. That's really, really impressive to hear about those efforts, Marisa and Lisa. I can't help but think of, all the, it seems like just anecdotally, there have been a lot of departures at DOJ recently, and I know they there's a hiring streak recently, and I just saw announcements of some more hiring. From your perspective, does the Antitrust Division, still have the resources to, effectively prosecute international cartels?
Well, you're right, Brent, that they certainly have been, their resources have kind of been stretched to the limit of late. As you noted, some very seasoned, experienced cartel prosecutors have left in the last couple of years, and there was a hiring freeze in place for at least 2 years at the division in the early part of this administration. As you also noted, there has been some recent hiring, and there was plans announced to hire up to 55 new attorneys for the Antitrust Division, probably a decent percentage of which would be aimed to become cartel lawyers. But who knows with the new pandemic crisis whether those plans are kind of thrown awry. But the division, I have watched the division do something wise. They were starting up a far left, and I know have continued it. And I think it's a good idea, which is to sort of enlist their merger colleagues as their eyes and ears in helping to detect the possibility of cartel conduct. In recent years, there have been several cartel investigations that have begun in the context of a merger that had received a second request. And as you know, these days, millions of documents are not uncommonly called for in a second request in a significant merger review. And by educating their merger colleagues, both in the DOJ itself and also over at the FTC, of what to look for and kind of some red flags and some language to look for, they've uncovered several. One that's very public and well known, of course, is the one in the tuna fish industry, where a merger of 2 of the 3 major competitors there revealed that, in fact, all three companies appear to be communicating on pricing, and that prompted a major international cartel investigation. So they've sort of learned how to expand their resources sideways by pulling in the merger teams and making them partners in detecting these cartels. And I know that there are several investigations that are ongoing right now that started in that way. The other thing they're doing, of course, is their announcement of being willing to give more credit for compliance programs. And the idea there, although historically the division has given little to no credit by companies having effective compliance programs, the concern that they had heard frequently from in-house counsel and company, then what is the motivation for companies to have effective antitrust compliance programs? So seemingly recognizing that, DOJ has now agreed to credit even up to including possibly resulting in a non-prosecution agreement if a company has a very robust compliance program. And the thought and the hope there, again, sort of enlisting others to do some of your work for you, if very robust compliance programs are being developed in-house, the hope is that that would root out additional cartel conduct and also be the basis for additional leniency applications if that kind of conduct is uncovered, or if not, at least having been developed, it might lead to more detection. So they're trying to think of creative ways to sort of expand their resources. And in addition, I think when you say, can they effectively prosecute, I think another important piece of that is being willing to follow through. And oftentimes there are a lot of pleas in a cartel investigation, but some individuals or some companies put the DOJ to the test and take them to court. And even though they had some lack of success, including in a major case that Heather prevailed in, there were two cases in the past year, one involving a tuna fish executive and one involving another foreign exchange rate executive, where the division did prevail in court. And I think that is an important indication that they do have good litigators and not to underestimate them. And so that message is important, I think, again, as an additional motivation for companies to come forward if they do find conduct that may be problematic, and to consider being part of the leniency program or otherwise cooperating. So I think in an ideal world, I think they would like to have more resources, but I think they're making the most of what they have.
Okay, thanks, Lisa. Well, I think we've reached the end here of this experiment to convert our spring meeting panel into a podcast. I really appreciate all of you spread among 12 time zones and 3 continents for making the time this morning to come together. I hope the post-production makes us sound great and very insightful. But thank you again. Thanks again, everyone.
Thanks, Brent. Lindsay, let's send it back to you. What were the 3 big takeaways from today's panel?
Sure. So the first big takeaway is that there's no consensus, right, on whether there's a global decline in cartel enforcement and investigations, which is super interesting. In the U.S., it sounds like Lisa and Heather both think we've seen a decline or we're in a decline, although there's some disagreement about whether it's a trend or just a moment in time. In Europe, international investigations are up, or at least steady from Marisa's point of view. And she made the great point that while some of the other jurisdictions might be focused domestically, anything the EC takes on is by default an international investigation. And in Japan, Atsushi made the point that whether there's a dip depends very much on the period of time that you're looking at for comparison.
Interesting. Okay. And what's the second big takeaway?
So second, regardless of whether investigations, enforcement actions are down, and again, doesn't seem to be a consensus on that, there is an agreement that leniency itself remains attractive. So the process of seeking leniency, although it's a much more difficult calculation than it used to be, the panelists seem to agree that leniency is still the best option if your company finds itself with a hardcore cartel violation or possible violation on its hands.
Excellent. And what's your third takeaway?
The third takeaway was one I didn't expect, and that's that the coronavirus pandemic may very well be a game changer in this space. The declining economy presents a growing temptation, frankly, for companies to come together to discuss prices and confidential business information in order to either maintain the status quo or try to stem the bleeding. So I think that's something that I didn't anticipate, that I thought the panelists really, their discussion about that was particularly interesting.
Lindsay, thank you. You mentioned at the top that you are the co-chair of the Cartel and Criminal Practice Committee. Tell us what the committee is up to and some ways that people can get involved.
Yeah, so we are having a very busy year. We are one of the more active, all the committees are active, but the Cartel Committee is particularly active. We just came together for the Cartel Workshop in San Francisco, which is held only every other year. So it's nice to get together and see the committee members and the section leadership all in one place. We hope to have some more international members of the committee coming out of that workshop attendance. We are going to put out a newsletter soon, reflecting on more deeply on some of the topics and panels that were addressed at the workshop. And for folks who are interested in joining us, this is a great time to get involved in the Cartel Committee. We have lots of publications underway. We have a grand jury handbook. We have a leniency and sentencing handbook. And we have a month or every other month, a bi-monthly update. And we try to rotate that across firms to sort of give the state of play of in the cartel world. And we've increasingly this year been trying to move to a format where we look not only to U.S. firms, but also to firms outside of the U.S. to lead that program.
Lindsay, thank you. And I also want to thank the panelists. And most importantly, I want to thank those of you who are listening. Please be safe and be well, and we look forward to seeing you next time.
Thank you for listening to this 2020 Virtual Spring Meeting edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the ABA Antitrust Law Section, visit us at ambar.org/antitrust to learn more. If you have feedback for the podcast or are interested in participating in a future episode, please reach out at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.